Hello, and welcome to Raising the Bar with the MBBA. I'm your co-host, Adeola Adejobi.
And I'm Jason Clark, president of the Metropolitan Black Bar Association. The MBBA is the largest association of predominantly African-American attorneys in New York. Our goal is to advance equality in the pursuit of justice, assist in the professional development of our members, and address legal issues affecting New Yorkers.
The goal of Raising the Bar with the MBBA is to foster a substantive conversation about justice issues in our community and to try to identify a couple of solutions in the process. Today, we're going to talk about wills and estates.
Joining us now is Preston Demouchet, Trust and Estates Attorney, as well as Kadeen Wong, also Trust and Estates Attorney. Welcome, and let's get to it.
Thank you.
So, I gotta say, we have been dying to do this show. I know, a little raising the bar here, humor. But actually, I mean, this is a very important topic. Before we get started, I did a little research, and according to caring.com, only 4 out of 10 American adults have wills. And when we're talking about millennials, 78% don't have wills, and 64% of Generation Zenners don't have wills. So, you know, we're definitely here and we want to make sure people know a little bit more about this topic. But as we're getting started, maybe we should start with some of the basics. So what exactly is an estates plan?
Sure, and thank you both for having me here. So an estate plan really is just a comprehensive plan that allows a person to anticipate and to plan and make arrangements for issues that arise during life, such as incapacity, and also after death, where you would like those possessions to go to that you own and who you would like those possessions to go to. As I said, it takes into account circumstances during your life. It can be a comprehensive plan that takes into account issues during your life as well as after death.
And I would add, it can also help certain individuals who have certain assets. Sometimes people have family businesses, artwork, family sort of artifacts that they would like to pass on to certain people. So a will is a great chance to give your express wishes. It's also a good chance for people who have minor children to appoint a guardian who would take care of your children if you pass away. And in the sense of who or how you leave assets, you can also leave assets to a child or a surviving spouse in trust. And we'll talk more about that today.
Yeah, and so we always hear about people dying without a will, but what is a will exactly?
Okay. So a will, the basic components are, it needs to be a legal written document. You need to be of age in order to create a will. And in New York, that's over the age of 18. And you also need to be of sane mind in order to create a will. A will is not effective until after you die, so during life you can change it as often as your circumstances change.
Yeah, and I would, to that point, I think people should definitely see their estate plan as something that's ongoing and ever adapting and evolving over time. We sometimes meet people who have wills that are, done, 20, 30 years ago, and for some people there's the thought that your plans are in place and everything is final, but you should always revise it and look at it.
Yeah. So to that point, when we're talking about estate planning, does everything transfer under a will?
So a will usually passes along your probate assets. That's the term. And then you have non-probate assets. But I think it's helpful to really understand what are non-probate assets, because I think that will help people understand what a will can do. So a non-probate asset that would not necessarily pass under a will would be a retirement account, like a 401k or an IRA, a life insurance policy. Some accounts at banks have transfer on death designations, meaning when you pass away, it automatically goes to a designated person. You also have annuities. That's one example. And there's always the classic example of 2 spouses owning real property with rights of survivorship. And you can have rights of survivorship with a sibling, for example. And that simply means a will is not needed when you pass away to pass that interest along. It automatically goes to the surviving owner. So those are different ways in which you have assets that do not necessarily pass according to the provisions in your will.
And so who do people typically leave their assets to?
Just before I answer that, I just wanted to add that the non-probate portion of that would be assets that you would typically think of, that such as your jewelry and your clothing. Those are the probate assets. So as Preston explained, the non-probate assets would be assets such as your retirement accounts, bank accounts that have the names of beneficiaries that are listed. But if you fail to list those names on those accounts, or to update those persons on the beneficiary designation for whatever reason, maybe they're no longer around, maybe they have passed away, then those assets, even though they were non-probate to begin with, are now going to be passing under your will, and so they are now probate assets. And another common asset that can be probate as well is tenants, property that are owned as tenants in common, where you own property with another person, you own 50% of that property, and another person owns 50% of that property. Your individual 50%, unless specified otherwise, is going to be passing under your estate, and so it's probate assets. And to your question before, who are your beneficiaries? The beneficiaries of your estates are, it could be people, or it could be organizations, right? So your beneficiary could be a child, a friend, a loved one, a cousins, you name it. And others that you could benefit are charities or your church. So your beneficiaries, it's like a whole slew of people or organizations, yeah.
Yeah, so, when we're talking about, so obviously this is a pretty, complicated, this can get very complicated very quickly. I know one question folks may have is, when they're figuring out who they want to, leave their assets to, maybe there's certain folks in their family that they want to leave to, maybe there are others who maybe they don't want to. Do you have to leave all your assets to certain family members, or how does that usually play out?
You don't. Typically, at the start of coming up with your estate plan, and as you talk about it with someone, it's good to have a sense of who would take your assets if you didn't have a will. And I'll talk about that in a second. But typically, you can include people in your family, and you can exclude people in your family. The one caveat I would say, and this is relevant in any state you live in, is the surviving spouse. If you have a surviving spouse, in most states, including New York, you cannot exclude your surviving spouse absent their consent. So there's a minimum amount that you have to leave a surviving spouse in New York State. Now, in many situations, that minimum amount can be satisfied with assets outside of your will or within your will. It just depends. But big picture is to know that if you're working on an estate plan, and not everyone works on their estate plan along with their spouse for a number of reasons, you have to be mindful that if you do not provide for your spouse in the will, that they are entitled to a minimum amount by law. And there are a number of exceptions to that, but that's more of the general rule. And what's also important when you come up with your estate plan is to consider who would actually receive some type of notice in the proceeding. So although you may not include your next of kin, so in the case of a married person, that would be the spouse and children, if those folks are not included in your will, in many instances, they will receive some type of notice or notification when you pass away. And they'll have a right to be involved in the proceeding. And I find, Kadeen would probably tell you, that does color the discussion a little bit, and some people think twice about whether they want to go all the way down the path of leaving someone out. So it's just something to keep in mind, yeah.
Right. So, for example, you may choose to benefit some of your children and not benefit others for whatever reason. You still need to give notice that the proceeding is happening, that you've died and that there's a will to be probated, and there is something called a will contest, right, where someone could challenge your will. And this is where the person could challenge for a variety of reasons. Some of them would include, my mom had a will, she didn't really mean to leave me out or to leave as little as she did. She only did so because of undue influence or because of fraud. Or because of some kind of insanity or incapacity issue. So these are also things that you have to consider as well. We usually tell our clients that if you are benefiting certain beneficiaries under your will, you should not have them sign or witness your will as well, right? To keep that separate as well, just to help with those issues.
Yeah. And so what happens when someone dies without a valid will?
If someone dies without a valid will, the state has basically written one for you.
Right. Right. That's worth highlighting. Yes. If you don't have one, someone has one for you.
Essentially,
Exactly.
by statute.
So the simplest form of breaking that down is that if you have a spouse and children, then the property goes to the spouse and children. If you have a spouse but no children, then everything goes directly to the spouse. If you have children but no spouse, then everything goes to the children. So there is a list that keeps dropping down. So what happens if you have no spouse and no children? It goes to your parents. If there are no parents, then it goes down to your siblings, and it continues down on. If you're interested or anyone else is interested, you can go on to the New York State court website, and they'll have a breakdown of how those assets will pass.
But just have a will, basically.
Yeah.
To avoid all of that. Okay, so with that being said, let's say someone has no family, no siblings, no spouse. Just to be very specific, what happens then?
It drops down, I believe, to your is it grandparents, and then to your cousins, I believe.
Okay.
Yes, from there. Right?
Yeah.
Okay, so they're going to look for someone.
Yeah.
Essentially.
Down near the lineal.
Yeah.
Right.
Exactly.
Right. And actually, and to your point, let's say they can't find any grandparents or what have you, what happens after that?
It goes to the state, right?
Right.
Yeah. So as we said, there's a list that it follows that goes all the way down lineally. And then if there are no one to take that property, goes to the state. And the New Yorks often have like a New York Unclaimed Fund website that you could search for, maybe a relative, because you just found out that they've died, and the state may be holding assets that you may be entitled to, and you then would have to follow the procedure in order to obtain those assets.
Right.
Yeah.
Yeah, and that's why, I think this is so important. I mean, I think people know about wills, but people don't always necessarily follow through in getting one. And if you want to make sure certain assets of yours are going to the right people, as opposed to going to, people who you wouldn't want it to go to, or in certain cases just to go to the state, then, you need to have some of this planning. But, let's say you're someone who may not necessarily be able to, afford an attorney who can be able to help with you. Are there certain basic things that someone could be able to do to try to protect, even some of their, some of their assets?
Yeah, I think there are a number of people who have, as we just talked about, they have mostly non-probate assets. So I would encourage that, people like that to create a list. If the assets are non-probate assets, you can figure out if there are retirement accounts or life insurance policies. Look at those designations, figure out who you would want to get those assets, and think about what happens if those people are no longer living. In that case, you would come up with a contingent list of people who can inherit your assets. There are services out there in a number of counties in New York where you can go into legal aid services, and they will help people write wills. So they're out there. So if you live in a different, in a certain county, I would contact your legal aid office in that county.
And I would just add to that if you don't have a will, but you have substantial asset or assets that you would just like to pass along, as Preston said, to keep your beneficiary designations updated. And there are also documents that we're planning to get into that you can basically put in place to make sure that everything that you have is being managed appropriately. We're going to be talking about your healthcare proxy, your live-in will, your burial designation forms, and your powers of attorney. So those are all valid, planning strategies to use as well.
Okay, and also, different states have different rules in terms of, what makes a will valid or not.
Yeah.
I'm not going to ask that specific question,
Right.
But what I will ask is, how does someone understand what state law applies to their will? Because, for New York City, it's a very transient place. You might have property in another state and live in New York, or you just go back and forth. How is that determination made?
Well, typically when you pass away, you have to bring your will, if you have a will, to the county where you were domiciled at the time of death.
Someone has to bring it because the person is dead.
Yeah, so in your will, you are going to appoint an executor,
Yes.
and they typically bring your will over to the county. But usually, it's the state you are domiciled in. That law typically, for most people, controls the disposition of your assets. So
I'm sorry, and domicile means?
domicile means your legal residence.
Okay.
Yeah,
And
sorry.
disposition means?
Disposition meaning passing your assets along. Who
Okay.
gets what, and how, yes.
So you could die in another state, but they're going to look at where your residence is, where all your affiliations are. So there could be for example, this issue comes up a lot where a client is elderly and they're moved to a nursing home, but they have lived, for example, for over 50 years in the Bronx. Their church affiliations, their, everything that they do are in the Bronx, but then they die at the nursing home. Well, are they domiciled there? Well, not necessarily. There is a whole bunch of case laws out there that you'll have to go through, the fact specifics and to find out where exactly that person is domiciled.
Okay.
Right. Yeah, and one of the things we also mentioned is when we're talking about estate planning, and you're actually starting to key this up when we're talking about healthcare processes or living wills, what are some of the other things folks should keep in mind in addition to planning for, after they pass away, but the planning for, during their life as well?
Yeah, we've talked a lot about what happens when you pass away, but you're right. The other component or aspect of an estate plan is to plan for the management of your health care needs and your financial assets during your lifetime. So one document is called the power of attorney. That gives someone who you appoint the ability to represent you and act for you in the case of anything financial related. So they can sign tax returns, they can speak with the bank on your behalf and manage your assets for you during your lifetime. And as our clients, lose capacity or experience diminished capacity over time, that becomes even more important. In terms of healthcare, you can appoint a healthcare proxy. That's a person who can speak to your doctor, the hospital, get access to your medical records if you're incapacitated. So those two documents together are very important because if someone does not have those documents, their family may be forced to do a guardianship proceeding in the state court, and that can be costly and very time-consuming. So it's an easy way to plan for your incapacity or diminished capacity over time. There's also a document called a living will, and that is a document that allows you to give your healthcare providers your instructions or wishes for how you would like to be cared for in the event of a terminal illness or as you experience, in end-of-life situations. So those three documents together can really account for, how to manage your finances and your healthcare during your lifetime. And I think there was one other document you wanted to mention.
It's very likely that a person will become disabled or lose capacity at a certain time. And so another form that gets overlooked often is your burial instructions, right? So your burial instructions or your disposition of remains, it's very important to make sure that any specific instructions you have with regards to where you would like to be buried, how you would like to be buried, any specific instructions regarding whether you would like to be cremated instead of buried, and where you would like the remains of any cremation to go. It's important to have those written out in a separate document that doesn't give the instructions under your will. And the reason for that is that you could be buried before your will is read, and so then your instructions weren't followed. So it's very important to have a separate document to dispose of any remains that you would have.
Okay. And in these last 5 minutes, I want to make sure that we have an opportunity to talk about trust, because I think people hear the word a lot, but they have no idea what it is. So what is a trust and how is it created?
Okay. I would first say that a trust is a written agreement between two people, and that's the grantor and the trustee. So the grantor, the settlor, is a person who is creating the trust, is the person who's going to be funding the trust. And the trustee is the person that you put in charge of those assets, right? You've given this person instructions, and they'll follow the instructions of the agreement when managing the assets and distributing the assets. Another key component of the trust is your beneficiaries, the person who you would like those assets within the trust to benefit. Would you like to?
Yeah, I mean, I would just say that I would think of a trust as a legal entity that you create, and it will be used to benefit people, and in some cases, you can benefit your local, nonprofits or churches or anything like that. They're helpful for some situations. A classic example is the blended family. Someone is in a second marriage and there are children from the first marriage. A trust is a great compromise where you can leave assets for the benefit of your second spouse, and when that spouse passes away, the remaining assets can then go to your children from a first marriage. If the beneficiaries may have potential marital problems of their own, creditor problems, if they're just simply too young, a trust is a great way to leave assets for them with a trustee, as Kadeen mentioned, who would manage the assets on their behalf. I would say it's not that simple for an individual to create a trust during their lifetime and pass assets along always. Most trusts that we deal with from time to time, and in this context of this conversation, is a trust created under your will. And that trust is created when you pass away, not during your lifetime. Some people can create trust during their lifetime where they transfer assets. I think the one thing we would say is be careful. There are a lot of income tax implications of transferring assets to a trust. So you should probably always work with a tax advisor, a trust and estates attorney when you decide to transfer assets into a trust.
Right. Another way is to create a revocable living trust, then once that trust will only get funded once you die. So it's created, but everything in your will pours over into the trust after you die. So that's another way as well.
Okay. Yeah. And we only have like another 60 seconds, but if there is one thing that our viewers should know or leave here today with, I guess it's in a couple of seconds, what would each of you tell that person?
Well, some of the common mistakes in estate planning is having outdated wills. Make sure that your wills are up to date. Make sure that your beneficiary designations are up to date, and that it also takes into account life changes. Maybe you no longer want to benefit a child that is now well-to-do because of certain tax implications. So maybe you want to adjust. So just make sure that all your documents are up to date and as you would like them to be.
Okay, great.
I would say just keep an open mind. It's a very complex process. Always think about what to do if you have a grandchild now, or if you have a new child, a new job, if you get divorced. It's an ongoing process, and always be open to thinking about how to change your estate plan or if it needs to be changed.
All right, well, thank you so much for being here with us today. And thank you for watching Raising the Bar with the MBBA on the Manhattan Neighborhood Network. See you next time.
Bye.
Bye.